Thank you, Mr. Speaker. I'm thankful to have the opportunity today to contribute to the second reading debate on Bill C-54, the Not Criminally Responsible Reform Act. This bill proposes to amend the mental disorder regime in the Criminal Code and the National Defense Act to strengthen their ability to better protect the safety of the public, as well as do a better job at responding to the needs of victims in the mental disorder regime. It may be useful to provide a bit of background on the existing mental disorder regime before I outline the amendments proposed in Bill C-54 and why there are important reforms. A fundamental principle of our criminal law, including the mental disorder regime, is that a person must be morally blameworthy to be criminally liable for a wrongful act or omission. They must have the mental capacity to know and appreciate what they are doing, and the mental capacity to distinguish between what is right and wrong. Also, they must be able to communicate and give instructions to their lawyer and understand the nature and consequences of a criminal trial in order to be tried. If, at that time that the act is committed, a person suffered from a mental disorder that rendered them incapable of knowing what they did or that it was wrong, the trial court can find the person committed the act in question, but order a verdict of not criminally responsible on account of mental disorder. If at that time of trial, the mentally disordered person does not have the capacity to understand the nature and the consequences of a criminal trial, they may be found unfit to stand trial. After either of these findings, the person will be dealt with according to the mental disorder regime, which is designed to balance the twin goals of public protection and fair treatment of the accused, usually by provincially appointed review boards. The review boards are comprised of at least 5 members with legal and psychiatric expertise. As I noted, this bill contains elements which addresses both public safety and victims. In terms of the public safety reforms, the bill would amend the criminal code to clarify that public safety is paramount in consideration for the review board decision-making process. Although the Supreme Court of Canada has said that the public safety is already paramount consideration, most recently in the 2000 judgment Regina and Conway, this proposed amendment will ensure consistent application in cases across the country. The reforms would also codify the Supreme Court of Canada's interpretation of significant threat to the safety of the public, which is the current test for determining whether review boards can continue to supervise the not criminally responsible accused. The Supreme Court interpreted this phrase in the 1999 case in Winco. The amendment would also clarify the accused need not pose a threat of violence, but must pose a real risk of physical or psychological harm to members of the public that is more than merely trivial or annoying, and it must be criminal in nature. This will ensure this test is applied consistently across all jurisdictions. Bill C-54 also proposed to create a new high-risk mentally disordered accused designation scheme. This new scheme would only apply to the accused who were found not criminally responsible for a serious personal injury offense. The mental disorder regime defines a serious personal injury offense as an indictable offense involving the use or attempted use of violence, conduct endangering the life or safety, or sexual offenses. In these cases, the Crown would apply for the high-risk designation to be made by the court. This designation can be made in 2 situations. The first is where the court is satisfied that there is a substantial likelihood that the not criminally responsible accused will commit violence that endangers the life or safety of another person. The second part is if the court is of the opinion that the offense for which the not criminally responsible accused was found to be not criminally responsible